Chair recognizes the member for Cat Island, Rumkey, and San Salvador.
Thank you. Thank you, Mr. Deputy Speaker. It's just interesting when the shoe is on the other foot. Mr. Speaker, the Interception of Communication Bill anecdotally described now wearing the shoes as the spy bill. What an about face. From a spy bill to an effective crime fighting tool necessary for the needs of the police today. What a flip-flop. There's now the need to dispel any notion that this is a spy bill. You know, Mr. Speaker, the Prime Minister on the 24th of February 2017 said these words: let's call their spy bill for what it is. An effort to gain a political advantage for an oppressive government. Man, you have to read the bill and understand it if you want to interrupt me and talk to me about the bill, because you don't understand it. You don't understand it. Right? So let's call this bill for what it is. An effort to gain a political advantage for an oppressive government to use the power of government to intimidate and spy on Bahamians who would stand up to them. You know, when the bill was presented, I also had to remark to the person who laid the bill that, you know, again, I call it hypocrisy, I call it all those things, but, you know, it's very interesting. February 13th, the member for Yamacraw called it a dangerous spying legislation. Dangerous spying legislation. You know, and he really said,
Order. Members. Let at least Cat Island to do the introduction to his speech, please. Give him a. Yeah, just order, Yamacraw.
The bill will allow the Commissioner of Police or a person acting on his behalf to obtain a warrant from a judge to intercept and examine a person's communication from telecommunications operators, internet providers, and postal services, providing for interception of all communications networks, regardless of whether they are licensed as a public or not, for a period of 3 months unless renewed. A dangerous spying legislation. You know, that's what. Yeah, but y'all want to intercept everything too. That's why I told you need to read the bill. And I'll show you where you are wrong in saying that. You see, Mr. Speaker? And I'll demonstrate it to him. Because he obviously didn't read the bill. No, you didn't. So, you know, and Mr. Speaker, you know, and it goes on. You know, Dr. Menace also had this to say. This piece of legislation, the member from Kalani, which has been rushed and rammed down the throats of the Bahamian people, should not be allowed to stand. It is a breach of the privacy of the public at large. It is our fear that this bill has more to do with blocking any opposition to this corrupt government than being a useful crime-fighting tool. That's what they were saying. The same bill, you know. The substance of the bill is the same. It is designed to create a fighting tool against crime. That's the and by intercepting communications of persons, intruding upon the privacy of persons. That's what it is. You know, and that's what it is. There's a member who sits in another place. I will not talk about what he had to say about it. Mr. Speaker, what is so interesting, those opposite who spoke to the spy bill caught the attention of the Bahamian public. In fact, in a letter to the press on February 20th, 2017, right, a writer said, soon enough, corrupt police officers will be blackmailing us to keep our private business under their wraps. Politicians will be using embarrassing personal information to destroy their opponents. A writer. Yeah. And the citizenry will be afraid to express themselves honestly to their friends and family for fear that they would. And that's what they said, right? Well, they don't have to spy on me because I'll tell the whole country, thanks to the spy bill, I'm voting F and M. See, I'm just saying what you're able to persuade the Bahamian people that this bill was a dangerous piece of legislation.
That was your bill.
No, it was a dangerous piece of legislation.
That was your bill.
Right?
That wasn't the bill you presented.
See, and so, Mr. Speaker, they are saying that this bill that they now have is different from the one that was presented.
It is. It's an F&M bill.
I want them to show the difference. I'm going to demonstrate to them what the difference was. Right? I can show them what the difference was, but I want to know whether, in fact, the very thing they complained about then is the very thing they have now introduced in their bill. What you complained about then, you have introduced into this bill. That's what you have done. But I'll show it to you. See, again, you didn't read your bill if you didn't understand what I'm saying. You didn't read the bill. You see, if you read your bill, you'll understand what I'm saying. The very thing that was being complained of by yourselves, in fact, Mr. Deputy Speaker, has been introduced in their bill. Our bill responded specifically to the criticisms that were leveled against the Listening Devices Act by the Privy Council in the case of Maycock, which the member from Yamacore quite ably recited. And he said why. And their concern was that the right to intrude in persons' private business ought not to be in the hands of politicians. We responded to that. Our bill took it out of the hands of politicians and rested it in the hands of judges. That was our bill.
Right around election time.
Right, that was our bill. That was the bill. That was produced, Mr. Speaker. You see, there was an attempt by the member from Mount Moriah, the mover, to show that this bill is different than which they criticized while they were in opposition. It was suggested, and it is still suggested by him, it was today, and he still moots it. It was suggested by the mover that the bill that was proffered by ourselves, right, by us, that inspired this view that the bill was a spy bill, was because the bill dealt with any offenses. And of course, he went to trivialize any offenses by identifying some stealing by reason of employment, stealing little minor offenses, any offense, right? But I want him to tell me whether this bill excludes those offenses. It does not.
It does not.
It does not. It does not. In fact, their bill has introduces much what I would call jurisprudential challenges going forward. Right? You see what I'm saying, Mr. Speaker?
Listen to the QC.
That's what. In fact, Mr. Speaker, their bill is regressive. It's regressive. Regressive, right? Mr. Speaker, Mr. Deputy Speaker, this bill has been regressive because it still remains in the hands of the politicians to intercept communications for any offense. That still remains in the hands of the politicians.
Still does.
Still does. How? You only read the billing. Maybe the Yamaha could look at part 4 of your bill. You see, Mr. Speaker, the criticisms of the bill that emanated from the Privy Council, which dealt with the Listening Devices Act, which was what I call a bill that prohibited the use of listening devices for the interception of private conversation, etc. And they lamented the fact that in a modern democratic society, right, it should not be in the hands of politicians to determine whether a person's right to privacy should be so trampled upon. Part 4, which talks about part 4, the listening devices section. Part 6, sorry. Thank you very much. Part 6, not 4. Part 6, listening devices. You introduced it. You brought it right back in. We didn't have this in. And it speaks of any offenses. And it's Commissioner of the Police going to the Attorney General for any offense. And hear what you have caused to happen. Your bill sets up 2 regimes. Look at your Schedule 2. Right? Look at Schedule 2. And Schedule 2 speaks about specified offenses. So you list some what I call serious offenses, and you call it specified offense. And then you say for that you go to the Attorney General. And again, why would you have to go to the Attorney General? And then the Attorney General goes to the judge. Still in the hands of the politicians. You go to the politician. He then decides whether it should go to the judge. Take it out of the hands of the politicians. That's what the criticism was about. Leave it in the hands of an independent arm of government. That's what it was about. And that's what your bill does. It sets up 2 regimes. And here's the challenge you may find going forward if this bill were to remain as is. Right? You have, on the one hand, what you call the specified offenses under which one can get the warrant to intercept, and you can get a warrant of entry for specified offenses. That requires the intervention of the judge. I still don't see the need for the intervention of the Attorney General. I would have thought that the commissioner, and you as a police officer should be, that's what you should be contending for. Because I'm aware of many instances where police officers went to the Attorney General, and because the Attorney General had a different view, they were not able to do what they thought they should do. And that's the hands of the politician. Why, if you have a different view than the Attorney General, you don't allow the judge to decide? Let it go to the judge. Right? Go to the judge. Let's go to the judge. Let's go to the judge. Right? So, Mr. Deputy Speaker, so what I'm saying, Mr. Speaker, we are talking about a progressive piece of legislation. We are talking about responding to criticisms from the highest court of our land. All right? So what this bill does, really, that's gone what I call, they took what I call a solemnic approach. They're appeasing the Privy Council on one hand by saying, well, okay, what we will do, we will specify some offenses that will require the judge to deal with. And then we will leave some offenses as they were, still remain as they are in the Listening Devices Act. That's what you did, what I call a solemnic approach. But the problem you have here may very well be that any offense could very well include a specified offense, because you make no clear distinction between when the Commissioner of Police decides that an offense had been committed and or about to be committed, or he has reasonable suspicion that something is afoot, whether that be stealing by reason of employment or simply stealing a clip or papers, right? It doesn't do that. So look at the bill. I'm saying it's clear. I invite you to look at it in that fashion. You may introduce. So, Mr. Speaker.
You know, the lawyers ain't saying much.
Mr. Speaker, and what I say to the government, consider what you're doing. Right? Because that's what you've done. You set up two regime, and you may have a judge may be called upon to decide when the commissioner of police does go and get an order get permission from the Attorney General to intercept someone's telephone, for example, and that is challenged because evidence is about to be produced in court, because then you have, on the other hand, that may overlap into a specified offense, and then the court may be called upon now, what do I do here? It's unnecessary. And so, Mr. Speaker, they talk about this bill as far, if they go from section by section, by all what was presented by our government and what they went back, they only find that the difference is that they went back and introduced the Listening Devices Act provisions that allow the politician and the police, to listen in on conversations and intercept communications. That's what it does. Right? Mr. Speaker, get up and say that, and then let's make a point.
Are you yielding, Karen? Are you yielding to
I want
Mount Moriah?
to the member, Mount Moriah, because
He didn't stand.
So he might read the provision.
I didn't see him make any motions to.
No, he won't get up. So, Mr. Speaker, Mr. Speaker, I never said politicians listen on communications. What I said is that politicians and the police could determine whose communication could be intercepted. That's what I said. And it could be on any offense. That's what I said. Any offense. The same one he was complaining about this morning. The same stealing by reason of employment, the same stealing, the same moving of a paperclip.
Same illegal.
Same thing.
Gathering, all of that.
Same political gathering, all of that. That is still here. That was not in our bill. It's still here. Look at section 29 of your bill. Look at it. Look at 29 of your bill and tell me where my bill is different. Tell me. It's regressive. And so, Mr. Speaker, now I've always been challenged by the fact that the opportunity about this fact about politicians being involved in deciding on interception of communications. I've always been trying. We have now the power to deal with it. And, Mr. Speaker, I cannot, in this dispensation, at this time, this is 2018 Bahamas, agree and to vote for a bill that will allow politicians to listen on communications by our private citizens. See, Mr. Speaker, I accept that the introduction of our bill, the timing of it, may have caused a lot of anxiety because it was, in the height of electioneering. But suffice it to say that our objective and purpose in introducing the bill was, one, to upgrade and modernize the then 45-year-old Listening Devices Act that was passed in 1972.
Right before election.
Secondly, it was to allow the police, under the authority of the courts, not politicians, under the authority of the courts, to intercept the planning and execution of serious crimes.
Right before election.
Mr. Speaker, we recognize that in 1972, that the Listening Devices Act, when it was passed, emails and mobile data were non-existent. And the bill then was to allow law enforcement to keep, our bill, when it was introduced, was to allow law enforcement to keep pace with the rapidly changing communications technology. Yes, sorry.
The chair recognizes member for Sanan.
Saying section 29.
Sorry.
Sorry, section 29 as, oh, so 26. Okay, fine, thank you. No, 9 gives, sorry, Mr. Deputy, allows the Attorney General to authorize a wiretap. You're meaning section 29 with the amendments that are being proposed. Yeah, I just want to clarify that bit. So in other words, the bill as draft.
Order, 1 second.
Sorry.
Can one person
Sorry.
be on their feet?
Sorry.
Who's on?
The bill, sorry, save his time. The bill as drafted does not permit that. The bill as drafted with the amendments. No, what you're saying is, what you're saying is the amendments that have been tabled make the Attorney General have that power.
What I'm saying,
Yeah, those
It's that-
amendments do it.
yeah, these are the amendments.
You yield, Caroline.
We suggested we hold that in committee stage. Okay? Okay. Okay.
It's worse. See, I was speaking to the amendments, right? Which is a little better, because in months, if you wanted a renewal, that's the only time you go to court in the amendments.
Once.
You see, but as is laid, it was worse. The amendments, there were some improvements, because after 14 days, and you wanted a renewal, you could go to, the Attorney General can't do it without going to the court. So that is what it is. See, Mr. Speaker,
Kill the bill.
they know what they put here. They understand. They understand. They don't even understand what they're doing. Mr. Deputy Speaker? Yes. So you understand what I'm saying? No, but not. I'm trying to debate it. I'm trying to. Listen. First of all, let me just say that we understand, right? We accept that the interception of communication bill, that's a very important tool in the fight against crime. We accept that. We introduced the bill. But we thought, in keeping and being consistent with a modern democratic society, right? Removing any thought of political interference, something you like to talk about so often, right? So yeah, you all like to talk about so often, right? You can understand representative government soon. You will understand representative government, what it means very soon, right? So what I'm saying, Mr. Deputy Speaker, but what we said is that we need to modernize it and take it out of our hands, leave it with the police, leave it with the police and the courts. I'm happy with that, right? I go further, right? I go further, right? Now, if you look at some of the other benchmarking against other legislations, Jamaica or Trinidad, for example, even the UK, it's not just left there as we have left it. And I could say that the member from Engliston had much concern about the bill as was laid then. And we had not yet completely sorted what we were going to do in our own minds with the bill. Because the same reason why you're laid now. Remember, you heard why they laid it, right? So Mr. Speaker, I know, Mr. Speaker, listen, man.
You gotta answer the question. You gotta.
You want to talk about fraud with fraud. Mr. Speaker, Mr. Speaker, I'll be not distracted. Speaker, Speaker, I do not accept that the bill was fraught with errors. What I say is that there are various methodology, there are a lot of other policy matters as to how one is to implement the underlying principle of intercepting communications. And there are differing views on how that is to be implemented. And therein lies, the challenge is not in no errors, but I could point out to you that your bill is fraught with errors. For example, who is the director of Bureau of Investigations? You have one of them? Who's that? Could you tell me who that is? Oh, it's in your bill. You could tell me who it is. Since you asked me, you tell me. You have it in your bill. You have Director of Intelligence Agency in your bill. Who that is? I can tell you who it was in ours. No, you tell me yours. That pass. Huh? Yeah. All right. Let me give you enough. Let me give you two more. Let me give. No. No. Why you engage me? Because let me point out another one. Where is the Director of Corruption of Investigation Bureau? Where's the Corruption Investigation Bureau Act? Mr. Speaker. So I'm just saying, you asking me these things. That's like they're all in this.
Point of order. Point of order. The chair recognizes the member for Yamakura. Your point of order, Mr. Point of order, Yamakura.
Point of order, the honourable member who's fully cognizant of the proposed amendment table is misleading this House, because he would see that Section C of the bill is in committee to be amended to remove the whole question of the Bureau of Investigations. But he's also indicated.
No, it doesn't.
But he's also indicated that they had a director of the Bureau of Investigations that had no legislation, an illegal institution of intelligence.
Yamakura, you're saying that the member for Cat Island is misleading because it's in the amendment. Can you advise?
There's
Yes.
a proposed amendment which says.
I see that.
Thank you.
Okay, so you okay? Fair enough. So you accept.
Yeah. No, yeah, I am. Yeah. No, I'm just point. No, he wants to engage me. I mean, I was going to deal with those, you know. I was going to leave that. I was going to leave them alone. But he wants to put words in my mouth. And I just wanted to show him that he didn't read his bill. I'm sorry, the Mount Moriah didn't read his bill. They don't even understand his bill. Right? And so, Mr. Speaker, I think it is worth repeating. It is worth repeating that unlike the 1972 Listening Devices Act, our bill that we had put forward, a lot of which is contained in this bill that we now debate, a lot of provisions, a lot of it, yeah, but there's a fundamental difference here. And that fundamental one is that the reintroduction of the provisions of the Listening Advices Act, which includes all offenses for which the member from Mount Moriah complained about. He complained about it without recognizing that you all have reintroduced it. You see what I'm saying? Yeah. And so, but that I support it because I understand the need for this tool. Yeah, right? And so, Mr. Speaker, you're my partner, man. You're my general partner. So I want to repeat this, Mr. Speaker. The bill transferred the authority that was given to the minister, a politician, to a Supreme Court judge. That's what we want. This change was critically important as it enhanced the protection of privacy for law-abiding citizens. Because it was the Supreme Court, not the politician, that makes the determination that the communication may be intercepted. And you have the challenges where the police and the Attorney General may differ on matters. And you would want the politician's views on that. You know, and Mr. Speaker, there are some other suggestions that why the Attorney General should really not be involved in this aspect at all. And I will go deep. You know, I was going to, the member from Long Island had some very good commentary during, and his was less political, when he spoke on, I had a date, the member from Long Island. In fact, he inspired me today.
Good to know, man.
He inspired me. Oh yeah, February 18th. Yeah, when he spoke on February 18th, man, I don't have enemies. I don't keep enemies. Don't have them. You know, when he spoke about we have no independent director of public prosecution, Mr. Gibson said. We have no independent attorney general, and we have no independent commissioner of police. The officers of DPP, AET, and COP are all political appointees. And over the years have demonstrably answered to or been subject to personal agendas or the whims of their political masters in one form or another. That's the challenge that we have by keeping.
Cat Island, that was in his speech, or that was from a newspaper article? That's just for the record.
I quoted him.
From his speech, or
I quoted him. He said that last year. You said that last
not
year.
in the house, though.
You accept
he
that?
said it last
No,
year.
no, yeah, no.
Yeah, no. He said,
No, but Cat Island, I'm only asking because if you're taking that from a newspaper, then you can accept.
That's citing. I'm quoting him. I'm saying what inspired.
You adopted it. I'm asking, did you?
I adopt that.
You adopted.
And most of the things I've said.
So, Cat Island, you're accepting. Before you proceed, you were quoting a statement from Long Island in a newspaper article. I'm just, and you're accepting those those as your,
Yeah.
and you're gonna table.
I didn't intend to.
You intend to table.
No, I don't.
You don't intend to table it.
Yeah, I said February 13th. The Tribune,
When?
2017.
I'm Cat Island, I'm only saying because as you're well aware, are you gonna accept those, Cat
Yes,
Island?
I've done it. Yeah.
I'm not concerned whether it's yours or not. I'm concerned whether or not it's going to be tabled.
No, I'm
if you're going to quote, you're not tabling it.
I don't intend to. Now, Mr. Speaker, some of the concerns, for example, Jamaica and the Trinidadian legislation provide that the commissioner of police make the application and go straight to the court. That's a model I would recommend. All right? And with the Attorney General, some of the difficulty is the Attorney General is a political appointee and a member of cabinet. I was pointed out by the member for Long Island. The Attorney General can say no to the differences between the views of the police, the investigative authority, and he as a political authority. He gives political direction. And if he is aware of what's going on, God knows where that could end up. There are many challenges with it remaining as is. And we have been admonished to move away from it. And unless the bill moves away from a political hand in the interception of communications, we will not be able to support this bill. Mr. Speaker, that is my submissions in respect to the interception of communication bill. And as I said, Mr. Speaker, when the shoe is on the foot. I could quote a lot of more things you have to say, but I decided I will not do that, Mr. Yamakro.
As Yamakro. Yeah. As many. The chair recognizes a member for.
I don't need to stand.
Mr. Deputy, thank you very much. Mr. Deputy, I'm privileged to rise with the blessing of the good people of Southern Shores, who's responsible for my being here. I continue to be committed to them and their concerns. I continue to work to do whatever I can to add quality to their lives. I want to take this moment, if you would allow me, to offer condolences to the family of Joel Williams, who will be funeralized on the weekend. Also to the family of Stephen Joyce, who will be funeralized this weekend. Mr. Speaker, as a former police officer, with all of my love for policing still fresh in my heart, I feel obligated to lend a few words to the bill. I would not have been in this place when this bill was introduced by the members opposite, but as a concerned citizen, I would have followed, I would have listened to much of the commentary, and I too would have had some concern about the bill, but not necessarily the contents of the bill. I would have been concerned, Mr. Speaker, of the timing of the bill. You know, Mr. Speaker, having had 5 years, and then to be threatened by a fiery hot opposition, and then all of a sudden you decide you want to bring something like this, mindful that we were at that time in an environment where the country would have continuously begged for 5 years for an explanation about this NIA, their remit, their purpose, etc. And then to have this brought in on the tail end, mindful that the then opposition, now government, were hot on their heels, mindful that the person who was alleged, I could only say alleged, to be in charge of this NIA was being rumored to become a candidate. So, Mr. Deputy, we would have been concerned that if this were allowed to happen at that particular time, there was no guarantee. Human nature being what it is, there was no guarantee that the alleged leader of the NIA, I say alleged because it was never official or confirmed, that the alleged leader of the NIA, a potential candidate, would not have used that position to disadvantage the then opposition, now government. And so, Mr. Speaker, having said that, I'm pleased to hear, oh yes, that's where the garbage can. That's where. You see, this thing was unofficial, so they could tender their reports anywhere. So if they just drop it in the garbage can, and people just go and pick it up out the garbage can, and then come here and use it to mash up an opposition that was gaining, you know. But, Mr. Speaker, I'm pleased to hear that the leader of the opposition admits that the intent at the time was similar to the intent at this time, which is to empower the police officers with better, more modernized crime-fighting tools. And so we share that in common. I was also pleased to hear from the leader of the opposition that even great men, QCs, albeit, make some mistakes, because he admitted that there were one or two things wrong there too. Yes, and the honorable member went on to say that there were those among them that had reservations.
Like Eggleston.
And so, Mr. Speaker, Mr. Speaker, I want to say that if the intent was the same as it is now. The same police force, the same country that we want to be properly policed, the same country that we all want to keep safe for generations to come, the same country that we love. I think this is an opportune time to show our police officers, first and foremost, our law enforcement officers, that we're all with them. This is an opportunity to show the Bahamas that we all love, that we're all with them. We on this side are not claiming perfection. We on this side are standing on our intent as best as we possibly can to make the Bahamian people safe. And so we invite the honorable leader, like we did last week with the anonymity bill, to join us. Come on, one accord. Join us, and when we get to the committee stage, if not before, offer your amendments, and I'm satisfied that we will recognize and acknowledge your intent, honorable member from Cat Island. We will partner with you, as I would have partnered with you on several occasions. And the good people of the Bahamas, Cat Island included, our cousins, will benefit. And so we acknowledge what went wrong then. We acknowledge that we are in a different dispensation now, Exuma. And so I invite you, Exuma, to join your leader, and let's partner, and let's get this right. I look forward to the day in this House, Mr. Deputy Speaker, when there will be issues, particularly issues related to crime and safety and security of this nation, where we will show the minority who are involved in terrorizing our people that we are together. Yes, Angliston. Yes, Angliston. And South Andres, you know, I wasn't getting beat when I was in South Andres. When I made sure you were in all the pictures, I wasn't getting beat, South Andres. So I'm a team player, whether we're in Andros, whether we're in New Providence, whether we're in Exuma. And for the sake of the people that we claim to love and care for.
And we'll be in Exuma this weekend.
We ask that we come together, make the corrections. If we say we want to take the politicians out, I'm all for that. As the minister responsible for local government, I'm all about divesting some of this responsibility to another tier. I was ready to give you some in Andros the other day, but you left early. So, Mr. Speaker, with that in mind, having heard the leader of that side, I'm sure that this debate will wrap up in short order because the other speakers will follow, and they will note one or two differences, but they will all commit to supporting this bill, and we can move on to other matters that are in keeping with this compendium of bills to keep our Bahamians safe. With that, Southern Shores supports the bill.
As many, the chair recognizes the member for Angliston.
Thank you, Speaker. Speaker, I am privileged to rise today, on behalf of the people of Angliston to contribute to this bill. And I just want to give a little bit of background to it because we've heard a lot of, agile dialogue in here as to how we got from where we were the other day to where we are now, Speaker. But the interception of communications bill that was brought to this Parliament in 2017, February 2017, emanated, as you've heard, from a Privy Council decision that started in the Magistrates Court in the Bahamas and made its way all the way up to the Privy Council in the United Kingdom. And the issues of whether the listening devices, they were constitutional, etc. But in the course of that judgment by Lord Mance, who delivered the judgment, the case is Gordon Newbold, appellant, against the Commissioner of Police, respondent. Shanto Curry, appellant, against the Commissioner of Police, respondent. Sheldon Moore, appellant, thank you, versus the Commissioner of Police, respondent. Trevor Robertson, Devroy Morse, appellants, against the Attorney General of the Commonwealth of the Bahamas and Government of the United States of America. Melvin Maycock, senior appellant against the United States of America and another respondent. And this is from the Court of Appeal in the Bahamas. And during the Privy Council looked at a number of aspects of our Constitution and the Listening Devices Act. During the course of their judgment, they made some serious observations about the philosophical underpinning of the Listening Devices Act of the Bahamas. And this is what was said by Lord Mance. In these circumstances, the only substantial criticism that can, it appears to the board, be made of the present Bahamian system is of want of independent supervision, whether at the stage of initial authorization by the commissioner or subsequently in terms of want of arrangements for the independent review of and reports on the operation of Section 5 of the Listening Devices Act. It is necessary to consider where such a criticism might lead. If the problem is viewed as one of potential incompatibility of Section 5.2 with the 1973 Constitution, then that route is on the face of it barred to the appellants, et cetera, et cetera. In the face of that decision by the Privy Council, the Attorney General at the time, Alison Maynard Gibson, with the assistance of her agency, began to review the ruling and to make preparation to meet what were considered to be very serious observations about the way in which the Listening Devices Act was operating in intercepting communications and whether or not it met a test of impartiality and independence. Yep. It was on that basis. And in her, Alison Maynard Gibson's presentation on the matter, she said that the bill will enable the police, with the permission of a Supreme Court judge. This was the foundation of the bill that we brought. With the permission of a judge, not the commissioner, not the Minister of National Security, not the Attorney General, a judge, the judiciary, to lawfully intercept electronic communications of any kind once certain clearly defined conditions are fulfilled. Conditions had to be fulfilled even for the court. And she went further to say this: the bill enhances protection of the privacy of law-abiding citizens because it is the Supreme Court, not the executive, not the Attorney General, not the Minister of National Security, not the Commissioner of Police, that makes the determination that the communications may be intercepted. This is the first time that Bahamian law places this authority solely in the hands of the independent judiciary. The Supreme Court will ensure that adequate checks and balances are in place to protect the rights of privacy on the one hand and combat crime, including cybercrime, on the other. Any suggestion that this is a dangerous spying bill is false. Now, that is the basis upon which we came to this Parliament with that bill. And in the face of that, we had a lot of political commentary, and the member for Cat Island, Rumkey and Salvador has referred to it, but I want to reiterate it because while I understand that it's very uncomfortable to have to now extricate yourself from your words, your actions, and your positions prior to this moment, it is what it is. And I think we have to put it on the table because it is clear that there is a high-level degree of hypocrisy that is at play in this Parliament. And Mr. Speaker, when you look at what the current Prime Minister, who was then the leader of the opposition, he said on the 20th of February and the member for Cat Island has already referred to this, but I want to just for emphasis. He said that this bill, the bill that I talked about that says you have to go to a court, not what you've brought here. You've brought here less protections than we brought. He said that the bill we brought that says only a judge, this prime minister at that time, leader of opposition, said that the bill poses dangers and should be rejected. And then he said, this piece, apparently this was a Facebook post, this piece of legislation which has been rushed and rammed down the throats of the Bahamian people should not be allowed to stand. It is a breach of the privacy of the public at large, and it is our fear that this bill has more to do with blocking any opposition to this corrupt government than being a useful crime-fighting tool. No politician had anything to do with the permissions, only the court. But this is what the leader of the opposition said, and this is what he told the Bahamian people. And it was proximate to a general election, but the only relevance of that to these proceedings today is that it was exploited for political reasons. Not that it created a panic in anybody. It was prime ground for exploitation, which is what happened. Now, the bottom line is, now, Mr. Speaker, here we are. And you know, I remember the group We March? Remember them?
Yes.
In the black shirts?
Yes.
They said that they were opposing the bill too. They said, will the FNM, DNA, or UPM, whoever that is, repeal this bill if elected? Will you repeal this bill if elected? That's what your senator now in the Senate said. That's what he asked. I wonder what he's saying now, that y'all ain't repeal it, but you brought back one with a lower test and an inferior protection than the one that we brought at that time. And then he said that, he said, ask your candidates publicly so we can know who not to replace these Animal Farm characters with. So I got one question now. Who's the Animal Farm characters now, Speaker? Speaker, FNM said the bill, well, I'm a vegetarian, so I don't know what you pig. I'm a vegan, actually, so, you know. I way down the list, and I ain't there to pig. The Speaker, the FNM said the bill was dangerous and unconstitutional. And of course, my good friend Yamakro, you know, he took some strong positions, which I would have expected him to do. And I was hoping he would have taken us through the bill. I think it's, or someone, if not him, I think it's very unfortunate that we've brought a piece of legislation that was so controversial before the general elections, where you took such strong contradictions than what you're doing now, and you have not shown, no one in this parliament on the government side has taken us through the individual provisions of the bill so that the Bahamian people, who you purported to speak for just before the elections, so that they can have an understanding of what it is that you've brought to this parliament, the spy bill, as you called it, and let's use that terminology, that the spy bill you brought to this parliament, you've not even explained it to the Bahamian people. You've not explained it in this parliament. You just come and spoke with some general platitudes and some, you know, some sexy type of dialogue, but you've not gone through the provisions so the Bahamian people have an understanding of exactly what it is that you have brought to this parliament that will impact their ability, Mr. Speaker, to have their privacy, Mr. Speaker. So, Mr. Speaker, sexy, sexy, sexy. No offense, guys, but I don't make sexy in that from that point of view. Definitely don't. I'm so sorry. I'm Speaker, you know, the member for Southern Shores mentioned the anonymity bill as he's defined it. You know, there are a lot of lawyers talking now because a lot of Bahamians are actually shocked that the government brought a piece of legislation which the mover said is possibly unconstitutional. I think that says a lot about what this government will do politically, because they probably believe that it will have some currency out there when they themselves fear or apprehend that it may go against our fundamental law in this country. And here we are now today, Mr. Speaker. And as the member, Mr. Speaker, the member for the member for Cat Island, Rumkey, and San Salvador has said, and I want to reiterate what he said, correctly said, you have a two-tier system in this legislation. The first one he referred to, where you talked about, I think you have some restricted definition of the laws. And then you have this other provision, which is the tricky one in this bill. In fact, this takes us back to really the basis upon which the Privy Council criticized this country. And it's Clause 29. And it's this provision which you're now amending, because under this one you give it to the Minister of National Security, which I don't think the minister ever had that authority before this. This is what you brought here. You brought here giving a politician the legal authority to order people to listen to. So when you talk about politicians, we got to worry about you, because this is what you brought. What we brought said only a judge. You brought something saying the minister. You know, however, you've now brought an amendment, which we got today, where it allows for the commissioner, in conjunction with the Attorney General, which I think is the current position of the Listening Devices Act. I'm not sure why this is in here, except that it gives the authority to renew by going to a judge. But this allows for the Commissioner of Police and the Attorney General to agree to listen to intercept people's conversations where it is deemed necessary for that an offense is about to be or is reasonably likely to be committed. And that's the point the member for Caroline Rumkey is saying. It says an offense. Littering is an offense. The straw vendors out there you might have said that they were unlawful gathering. That might be deemed an offense. So the very thing you accused the prior administration of, which was not true, and the facts bear it out because the legislation was much more strictly drafted, even though I will agree the offenses were broadly interpreted, but it was a judge. What you have done in this two-tier system is allow for a commissioner of police and the attorney general to, amongst themselves, to make determinations where there's an apprehension of an offense. Not the, what's the language used in the other part? Ray, what's the language in the other part for the specified offense, which is specified in the schedule? We understand that. But you slipped it in here, I say. This provision now, any offense. So, Mr. Speaker, we cannot support this, Mr. Speaker. This takes us backward. We will not support this. The legislation we brought took us forward because it said only a judge. What you brought here now is putting a lower standard for the protection of civil liberties of Bahamians, and we will not support it. I recommend that you amend these provisions and put this in a way in which it meets the concern of the Privy Council about the standard that is now being exercised for the listening devices in our country. We're not going back on that, Mr. Speaker. So I advise this government, and let me just say this too. I know that in political circles, many people believe PLPs worse, uglier, fatter, etc., than FNMs, or vice versa. You cannot be arguing that something of this nature, this legislation, is safer in your hands. Think about that. And it's not about personalities or political parties. It's about the civil liberties of our people. And so in that regard, I would strongly recommend this government move forward to the highest standard, which is to ensure that it is a judge with certain criteria on his or her satisfaction that authorizes any citizen of this country, their conversations to be listened into, their mails opened, their emails opened, etc., that it is only from the independent arm of our government in this country that authorizes that form of intrusion. The Listening Devices Act in its current form has lived out its usefulness. Yes. It is now an anachronism, and it's not acceptable in the 21st century. And so I want to encourage the government to move to the highest standard. And I will only end with this last point. And I raised this before, and I believe that the member for Yamoussoukro raised it before, and what I saw in prior comments is that there are rumors, allegations, assertions that a foreign state has been listening to the conversations of Bahamians. I don't know if it's true. We can't seem to get the answer to it. To our conversations, foreign state. Right. Oh, you don't believe it, eh? Oh. So, is that a senator you're making, you okay with that? Mr. Speaker?
Pardon me, I didn't.
Yeah, no, I'm just wondering if the gallery is not supposed to be, there's no member in the gallery that should be participating in debate.
Oh, well, one second. If in fact that was the case, just a warning generally to the gallery. The gallery is to please do not engage in any comments or any body language to the chambers, please. Otherwise, we would instruct the Sergeant at Arms to take measures that I don't think you'll be happy with.
Thank you, Mr. Deputy. I truly appreciate that. Yeah, excellent. I mean, this is a first-class speaker. This is a good speaker. Good speaker.
Carry on, Anderson. Carry on.
No, Mr. Speaker, but seriously.
Carry on, Anderson. Carry on.
No. Seriously, Mr. Deputy, I appreciate that intervention. Thank you, Mr. Deputy. So, I only put that out there so that there is still a continuing concern. But, Mr. Speaker, in the 21st century, the right to privacy and, social media and all these things. I mean, just the other day, the Prime Minister was commenting something with it appears, the Commodore of the Defense Force. And it became a headline. I'm not sure whether, it was intended for public consumption. I don't know. But it just tells you that, your privacy is a serious, sacred thing. And that we have to find ways to ensure that people are able to enjoy these amenities while we have, in the time we have on this planet. So, Mr. Speaker, I just end by saying that the bill that we brought was, I think, philosophically sound. There's one other provision. I wonder if I'm reading this correctly. I'm not clear on the amendment. Is this amendment giving the control of customs the authority to request listening devices? Because if it does, I object to that. See, this came to us also, where you start broadening this power to start listening to people's conversations. This should be narrowed and not broadened. And I'm inviting the government. And they have direct immigration, this too? No. So I want to invite the government to also look at that, because what you're now doing is seeking by this legislation to give powers to persons in this country or entities that did not have the power before, and you're actually expanding the authority to listen to people's conversations. And I'm going to recommend that you narrow that, not expand that, Mr. Speaker. So, Mr. Speaker, I just want to say that the bill that we brought, while I believe, that the offenses should have been more tightly defined, the fundamental principle, which I agreed with wholly and solely, was that you had to go to a judge. And that gave me a comfort level of sorts. If you're going to have the power to listen, at least have an independent, impartial individual who weighs in the balance the issues and makes a decision, not the politician, not the commissioner of police, Speaker. And so, Mr. Speaker, I want to reiterate that that was our objective in response to that Privy Council case, and that was the philosophical underpinning. The government has found itself, after having tangled itself in the political rhetoric of settling down and understanding that it's the police who say this is a necessary tool for the sophistication of crime. Oh, yes, I have it here. I'm not going to call any names. Well, who you didn't say the police said they would believe that it's a necessary tool for them? Okay. Well, I believe the police are of the view that they need this tool. And I think that's the reason you're doing, because it's the police who will be executing. So I'm assuming that is where you'll be guided. They're the ones who say they require it for their purposes of law enforcement. So that's the point I'm making. So, Mr. Speaker, I think that when the government caught itself after all of the political rhetoric and understood what they were confronting, that they had to come traipsing back into this parliament and bring this same legislation. The whole country knows you backtrack, double dip, you know, do the bank, what do you call it, the moonwalk, flip-flop. You've done all of that. The country doesn't know that. You know, where you could say whatever you want, you could frame it however you want. The country is very smart. We don't know you backtrack. However, I'm going to urge the government to take out the offending provisions, because we will not support anything that does not provide the highest protection for civil liberties in this country, while at the same time facilitating what may be deemed to be necessary in the enforcement of law and for the greater protection and national security of our country. And so, Mr. Speaker, on that point, that's our position. Thank you.
As many, Chair recognizes the member for North Abaco.
Speaker, as I take to my feet in this place, this honorable house, let me show Angliston that not everybody believes, at least on this side, that PLPs are ugly and fat and all of those other derogatory adjectives used to describe PLPs, because when I look upon Angliston, when I look upon Angliston, I see all things diverse to those things which he has just stated. You know, Mr. Speaker, the realities of governance can be sobering, very sobering. In government, you seek to make decisions and to create policies that are in the absolute interest of the governed. More times not, you hit the mark, and as life would have it, sometimes governments miss the mark. But in this instance, Mr. Speaker, having spent all of my life in the nation's military, now sitting in the cabinet, I am convinced that this government is making the right decision with this bill. You know, before I hit my stride here, let me just say this. What we're dealing with in this dispensation, right? What we're dealing with in this dispensation is what the social scientists refer to as a dilemma. It's a security dilemma, because you are struggling to marry democratic and fundamental rights with issues of security. These issues heretofore unseen or unknown. And it is a struggle. And you know, Cat Island, as we strive to hit this mark rightly and correctly, even large countries, developed countries who've been around for many, many years, hundreds of years, some of them, are still struggling to balance that paradigm, to find the right, correct balance between fundamental democratic rights, balancing them, and security, because of the nature of the world in which we now find ourselves. And so at this point of our development, Mr. Speaker, even the staunchest skeptic cannot, with a straight face, genuinely disagree with the notion that policymakers and those charged with national security hold a solemn obligation to keep citizens safe from all who wish to cause them harm. You know, long gone are the days of my Grammy in North Abaco, where you could sleep with your windows open and sleep with your front door unlocked in case somebody needed a rest for the night, and they would walk in and you would be safe. Even in my days growing up in North Abaco, you could leave the keys in your ignition and never even worried about your car. Because if an uncle or a cousin or someone came by and saw the key and they needed to do something to the car, they jumped in and they drove off, but invariably they bring it back and you had no concerns. But the reality is, Mr. Speaker, is that we live in a different world, one that is constantly evolving always changing, and as such, we can no longer ask our security forces, the hardworking men and women in uniform, to keep us and our families safe with one hand tied behind their back. We must adapt and change with the circumstances and dynamics of our times. We must make available to them all of the tools of modernity through this unprecedented advancement of technology that the world now has to offer. Only then can we honestly hold them true to their charge. Now, much has been said about this case, and the Privy Council decision in the matter of Melvin Maycock, short version of the name, which was decided on the 16th of April, 2014, my birthday, literally challenged the constitutionality of the Present Listening Devices Act. Among other things, it declared that there was a lack of judicial or independent oversight. In essence, what was happening is, as pointed out by my learned senior so ably, it lacked the ability for there to be independent judgment of the actions of the authorities. And as we strive in our best interest in a democracy in which we find ourselves, there must always be oversight. But I'm going to come back to that a little later on. Today, we seek to remedy that problem, not only for ourselves, but also because we do not exist in isolation. Mr. Speaker, September 11, 2001 changed the world forever. The 9/11 Commission report, replete with interim reports and press releases and an index of the final report at pages 241 and 242, and I have it right here, you know, if anybody wants to have a look at it. It mentions the Bahamas in connection with two of the terrorists who flew from Fort Lauderdale to Freeport on May 19th.
What?
The two had booked reservations at the Bahamas Princess Resort, but they were turned away by immigration officials upon their arrival because they did not have a visa. You know, we say all kinds of things about our immigration officials, but they got that one right, eh? They got that one right. In the result, the two returned to Florida on the same day. The Commission notes this about their excursion into the Bahamas. It says that the two likely took this trip to the Bahamas to renew one of their immigration status relative to his stay in the United States, which would have come to an end on May 21st. And so the bringing of this bill is not to instill fear, as believed by some, but to keep Bahamians safe in a world where there is little value for life. Mr. Speaker, that said, we must recognize that the people the world over are distrustful and exceptionally cynical about governments and security service. Quite frankly, there's generally a distrust of governments everywhere we look. And as such, I expect, well, rather, we expect that the civil libertarians among us and others will harbor a fairly high level of skepticism over what we do here in this instance. We in government and the security services must work to earn their trust as we seek to protect the citizens of this country. You know, truth be told, we on this side were clearly distrustful of the other side when they sought to enact their version of this bill, just days before an ensuing general election. The party that had lost the trust of the people. And then you come to the people and ask them to accept, in the waning hours of your administration, in the waning hours of your administration, a bill that risked prying into their personal and private circumstances. And so you cannot blame us on this side or Bahamians for rejecting that concept. It was too late in the hour, Angliston. it was too late in the hour. Too late. Too late in the hour. But you know, I have heard it said frequently in this place, you know, and elsewhere, all across this country, that loose goat know how tired goat feel. Yeah, yeah, you know, I went to a seminar the other day, and the presenter said, you know, the same knife that stick goat, stick sheep. And so you are on that side and we are on this side. But it's the same knife. So as you craft these terminologies of hypocrisy and the rest of it that we represent across here, we appreciate what you're doing, and we appreciate that you understand where we are in the season of our lives. For we are in the seat of governance, and governments are required to make tough decisions. And I want to take this opportunity to commend my brother, the Minister of National Security. I want to commend him. I want to commend my brother, not only for the job that he's doing in national security, but for grabbing the courage of his conviction and come to this place and put protection of the Bahamian people above his pride. And this place, because he sees the big picture from where we sit. We, Mr. Speaker, will earn the trust of the Bahamian people by operating in accordance with the law. That's how we will earn their trust. In this regard, we in the Bahamas are not exceptional. All governments and security agencies must now learn to earn the trust of those whom they govern. You know, among the major challenges of our times, we are faced by, in all democracies, with this issue in democratic countries, where we grapple with finding the right balance, as I alluded to, of protecting fundamental rights and protecting the citizens which these rights will serve. It's not an easy task. People who, in fact, place no value in life, Sir Andres, you can make a transatlantic voyage right now in some aircraft within six and a half, within 7 hours. People who place no value on life will use those weapons, will weaponize airplanes, as we saw on September 11th. Weaponize them and fly them into office buildings and other places where populace gather. And in that instance, some 3,000 lives were lost, and some more than 6,000 others maimed. That's the big picture here. We're not here in this place to argue about semantics of the language of the law. We will correct that. We will correct the issues with the law. I accept that there must be complete judicial oversight of what we do. That is why we live in a country that is governed by a constitution and the rule of law that provides for us. Where's my constitution? Somebody moved it. Separation of powers. Separation of powers. So when we come in this place as legislators and we create laws that are odious to the Constitution, right? Then there's the judiciary, who will go and have a look at those laws and examine them and see how they offend this Constitution and require that corrective measures be taken to fix it. Because this Constitution protects the fundamental rights of the Bahamian citizen. This is the supreme law of the land. And no law we make in this place, no law will stand the light of day that defends this Constitution. You know, in recent years, these heinous acts of mass murder by terrorists have become all too frequent. We've seen them in Europe and North America and in the Pacific realm and in the Middle East. And we've seen them in cities like London and Barcelona and Nice, and more recently in Toronto. our fellow Commonwealth country, Canada, have all been afflicted by violent and deliberate acts of the murder of people simply going about their daily business. This is the big picture. When you sit in government, you must always see the big picture. We can sort out those issues. But more importantly, what we do here, the big picture is protecting the citizens of the Bahamas and those millions of others who visit our shores and expect to be protected when they come to these shores. But you know, this is the nature of the world in which we live. A world where terror, which knows no borders or limits, is used as a means of furthering political ends. A world where modernity has enabled transatlantic flight in 6 hours or so. And so, Mr. Speaker, although we in the Bahamas and the Caribbean have not been, by the grace of God, impacted by terror, we cannot rest on our laurels and assume the ostrich position, burying our heads in the sand. We too must continue to do all within our powers to keep Bahamians and the thousands of visitors to these shores as safe as humanly possible from those who would wish to cause them harm. That's what this legislation is about. It's about adjusting our efforts to address the challenges of the 21st century. This bill is about national security, the national security of the Bahamas. It's about enabling our crime fighters and national security operatives to fight in our behalf. It puts one more tool in the toolbox of national security operatives and institutions to better safeguard Bahamians and others from these transnational criminals engaged in gang-related law-breaking, drug trafficking, gun running, and human trafficking, and child pornography, illegal immigration, and other such cross-border criminality. So we can't get bogged down in the minutiae of legal antics and discourse. We have to find a way to live in this 21st century in which we find ourselves. And so simply put, this bill responds to the myriad technological advances in an unprecedented technological age and the existential threat of terror and transnational criminality that we deal with. Yet it strives to protect Cat Island. It strives to protect the privacy of Bahamians through independent oversight by a judge of the Supreme Court who's clothed in security of tenure. Governments are expected to protect their people. This bill puts us in a better position to do so. And so today, Mr. Speaker, this bill enables law enforcement to capture the newer encrypted forms of internet-based communications, a method favored to be used by those who wish to cause harm. Toward this end, Clause 3 of the bill forbids the intentional interception of a communication in the course of transmission by means of a public postal service or communications network. Those who do so will be subjected to a fine of $50,000 or imprisonment of 4 years. Clause 5 of the bill is very important because it provides for the much-needed judicial oversight of which Angliston and Cat Island referred. The oversight intended to mitigate abuses by our security forces. A judge must be persuaded by those seeking the issuance of a warrant for the prevention or detection of a specified offense, and will only do so where there are reasonable grounds to believe that such an offense has been, or is being, or may be committed. Clause 6 provides that the judge to determine a specified time for the duration of the warrant, and that time may be extended under Clause 7 if it is justifiable in the application made by the Attorney General. So in this instance, there are two levels of oversight. As the authorized officer seeking such an extension must then convince the Attorney General, who must then in turn convince the judge that the extension is necessary and just. Clause 8 provides for the application of an entry warrant resultant of the related interception warrant. It is important to note that this legislation only permits the issuance of an entry warrant to install a listening device only where an interception warrant could be justified. Clause 9, Mr. Speaker, provides for determination of an interception or entry warrant where a report is not delivered to the judge. That report is required under Clause 12 of the bill. So you see, this bill has several layers of protection for the citizens of the Bahamas and others who may find themselves exposed to our laws. You know, you can go and get a warrant, you can enter, but then you got to come back to the judge, right? And the judge requires that you report to him or her on what is going on in your quest. And Clause 12 speaks to that. Under Clause 10 now, it provides for an oral application to be made by the Attorney General on behalf of an authorized officer for an interception or entry warrant, or both, or for a renewal of either, in the outcome. So Clause 10.5 requires afterwards that a written application and a sworn affidavit in support thereof be provided of an oral application within 72 hours following the issuance thereof. You know, it is, say again? Yeah, you know, so there are going to be times in this world in which we live, everything ain't wrapped up in a neat little package, you know. Sometimes the authorities may come into some information that they need to move on expeditiously. And so they go to the Attorney General and say, look here, you need to make an oral application to the judge so that we can move now because lives are at stake in their humble estimation from the evidence that they see before them. And so, so the Attorney General then is able to go before a judge and make an oral application, right, to deal with the exigencies that he faces. An oral application, and then in 72 hours, oversight kicks in again, but you can't wait sometimes when lives are at stake. And so you have to move urgently. You with me, Exuma? You move urgently, all right? In the interest of the public and the interest of saving lives. And so in the aftermath then, the written report is given accompanied by a sworn affidavit. It is my considered view that there may always be times of urgency when such an action is required. Clause 17 of the bill seeks to safeguard and protect any records obtained pursuant to an interception warrant by requiring the destruction of such material that does not relate directly or indirectly relate to the purpose for which the warrant was issued. So this particular clause here prohibits the authorities from going on what we call fishing expeditions. So if you are collecting or gathering information and data or whatever, and recordings, and you find that the information that you've gathered does not necessarily apply to the case that you're looking at, the court will order that information destroyed. And then this bill goes on further to say unauthorized disclosure of such information, it makes it a criminal offense. It makes it a criminal offense under Clause 20 of the bill. And so it is a criminal offense for anyone to disclose any intercepted confidential information captured during the life of a warrant. And so if you're in a position where you are under investigation and information is gathered and that information is not pertinent or material to the investigation that concerns you, that information is destroyed. That is destroyed. And if someone discloses that information, personal and private information, that person then will or should find him or herself before a court where they will be duly dealt with. And so in conclusion, Mr. Speaker, this bill, which addresses which addresses, my glasses for that one, which addresses protected information in part 4. It speaks to communications data in part 5 and listening devices in part 6 and listed equipment in part 7 and part 8 covers miscellaneous issues. Despite the necessary, clandestine nature of intercepting communications and to keep us safe, and it is our duty to do all within our powers as a government to be as transparent as possible and how we use the authority this bill seeks to grant when it is passed. We've seen the mistakes made by large developed countries. We've seen mistakes, the issue in the United States and the United Kingdom and elsewhere in Canada, where authorities went a little too far and invaded the fundamental and personal space, fundamental rights and personal space of those whom they sought to protect. And that can happen when you get embroiled in the fight. You get embroiled in the fight, and so you need checks and balances and oversight to check unfettered use of authority. And that's what the courts are for. And hopefully, along the way, in the various steps of progression, as we move, we will become better at what we do. But we can't sit here and wait on perfection before we move. This is far too important. And so if there are issues that we need to sort out, we need to come together and sort them out. In fact, that's why the people sent us here. They sent us here to sort out issues, to do the heavy lifting. And so I am convinced, Mr. Speaker, that we have put in place the necessary oversight to mitigate abuses of the fundamental rights of our citizens. If those charged with oversight remain vigilant as they act in the interest of their nation, more and more democratic governments are being forced to make decisions that challenge the need for balancing fundamental and civil rights with the inherent expectation of citizens that they should be always protected from those who wish to cause them harm. Threats associated with terrorism, nuclear proliferation, and cybercrime, and many others, all of which recognize no boundaries, are with us and are not likely to go quietly into the good night. They are with us. And so the challenge of our time, the challenge of this government, is to keep Bahamians and others safe while maintaining their trust. We need to maintain their trust that we will do all that is necessary to protect their fundamental rights. Let's not kid ourselves, Only the strength of the law will constrain those in authority. And so, if those in authority act outside of authority, we must use the law to bring them back into line. And I expect, as we're seeing in developed countries like the others that I've mentioned, we too will go through our growing pains. We strive to balance security, democracy, the protection of fundamental rights. This outcome is described by scholars of the subject as the dilemma of intelligence and democracy. On the one hand, democracy calls for accountability and transparency and the respect for the rule of law and human rights, while intelligence agencies, at least at some level, need to operate in secret and intrude in citizens' lives. Liberties in order to be effective. And that's according to an article that I read. One, quite frankly, an article that I participated in. But I am confident that our Constitution, which provides for the separation of powers, is strong enough to enable the necessary balance we need as we make our way in the world filled with many varied, diverse, and dynamic challenges. And so, Mr. Speaker, with that, North Harbour Code commends this bill and wraps up this debate. And I thank you.
As many. Chair recognizes the member for Bamboo Town.
I do move that this time that the, you did take the, oh, you got to take the vote. Yeah. Second.
The bill be read a second time. Order that the bill be read a
No, we're not
second
going to
time.
go into committee yet.
No. As many that's in favor would remain seated. Those opposing will rise. As many. Order, members. The bill is being carried. Order that the bill be read a second time.
A bill for an act to provide for the interception of communications and the provision of information for interception in the Bahamas and for related matters.
For the second reading, the chair recognizes the member for Bamboo Town.
Mr. Speaker, I was trying to head them off at the path. But Mr. Speaker, I do now move that the House suspends. It's our intention to do so. And we will return on 10 a.m. Wednesday, the 9th of May, 2018. And Mr. Speaker, at that time, the 9th of May, in 2 weeks.
The eve of the election.
In 2 weeks.
Would it be wonderful here?
Well, you'd already lost it, that's
In 2 weeks. And on that date, Mr. Speaker, I wanna signal to the good house that we intend to debate two bills, the Jury Amendment Bill 2018 and Access to Affordable Homes Bill 2018. And I understand that the member for Engliston will wanting to speak to her request for a select committee on the 9th. And we will be taking up all those matters on the 9th. And so now at this point in time, Mr. Speaker, I do move that the House suspends to 10 a.m. Wednesday, the 9th of May, 2018.
It's been moved and seconded that the House do suspend until the 9th of May, 2018 at 10 a.m. As many members that are in favor will remain seated. Those opposing will rise. The business of the House is suspended until the 9th of May, 2018 at 10 a.m.